I really love the sequencing of today. So we've started with some really inspirational and aspirational stuff from Tim. We've gone on to be even more inspired by Richard and the work he and his team are doing. We've then had it all backed up with some really well articulated evidence from our researchers. Started to probably peak around there where we were seeing data and stats and some citations. Now we've heard from Paul, who at least had some elephants and ski runs in his presentation. Now we finish with me talking about this thing, the law. So I'm privileged to be able to try to not have you throw rotten fruit at me. So I've heard a few things today which are really interesting, but I want to start by pointing out what WorkSafe is. So WorkSafe Victoria, like all of the work health and safety authorities, regulators around the country, we are charged with monitoring and enforcing compliance with occupational health and safety law. This one we have in Victoria is a bit different from the rest of the country. They all sing from the same hymn sheet. This is our own one, which theirs is modelled on. We have yet to come to the party, but essentially it's all the same. And what it mostly does is lay out the legal obligations of employers and a few other duty holders under the Act. It's worth pointing out, if you don't mind, Andrea, that the OHS Act is what we call a criminal statute. So that means that provisions under that law include, and penalties under that law include indictable offences with penalties including jail time and significant fines. So it is a fairly strong constraint. However, having said that, what we operate under at WorkSafe is what we call it our prevention service model, but it's basically just an adaptation of an old idea in regulation, and we use sort of a pyramid or a triangle to show our toolkit, if you like. So at the top of our toolkit, we've got all the big stick things of prosecutions and enforcement. Down the bottom of the pyramid, we've got education, empowerment, influence, moving up the tree, coercion, and then we sort of get heavier and heavier. But our preference is always to work in that bottom space. So supporting that, we do have a whole range of education activities, and I quickly looked at our website to see that our main things that our website says we do, that we monitor and enforce. We make recommendations to the Minister and to Government on the regulations and the legislation. So we can do that, but you can do that too. Anyone can do that through their local Member of Parliament. All Acts of Parliament have a cycle and they're reviewed every 15 or so years. Ours is not up for review for a while, but ministers can choose to make changes to legislation. So bear that in mind when we look at some things that we'll probably all agree might be worth reviewing in this Act. But the other things we say that we do are we promote public awareness and discussion about OHS and welfare issues, and we publish OHS stats. Some of the other things that we'll touch on, it'd be interesting to unpack a little bit, and perhaps in the panel discussion, this idea of reasonable practicability versus what a reasonable person would do. And Tim mentioned that, and there are distinctions, and I'll talk a little bit more about those. And then also, two other key things probably, safety versus health. Is there a difference? What's the difference? And the notion of risk versus benefit and how that plays out in our legislation. So, Andrew, if you don't mind, please. These are the main bits that I think are relevant to people who provide risky things, who deliberately, who are employers, therefore duty holders under the Act, whose conduct, the conduct of their undertaking, involves deliberate engagement with risk. So what you can see there, that's section 4 of the Act, is a principle saying that duty holders under this Act owe the highest level of protection against risks to health and safety. And here's the key, that is reasonably practicable in the circumstances. And that reasonably practicable phrase will come back again and again. And so we go to I've skipped over section 21 because it's not particularly relevant here, but the main section of our Act that talks about employers' obligations to their employees, and that includes contractors and other people down that chain, that's not so relevant here. But this one is. Section 23 of our Act is about persons other than employees whose health or safety is affected from the conduct of the undertaking of the employer. So as you can see in that section 23.1, an employer must ensure, so far as is reasonably practicable, that those people, and that includes kids in playgrounds, if the playground is within the conduct of the undertaking of an employer, importantly, there is an obligation of that employer to ensure, as far as reasonably practicable, that risks to their health and safety do not arise. So what does that mean for engagement with risk? And the last one that's relevant here, I'm not exactly sure how that may play out in the space of the design of play spaces or the running of play spaces. It certainly can be relevant to activity programs, perhaps like yours, Richard. But it's about not running the show yourself, but having some sort of management or control over that. So a typical example might be Camp Manyang. So Camp Manyang is the employer is the YMCA, so they have certain obligations, but the YMCA is managing Manyang on behalf of the state government. So the state government will have some obligations under Section 26. And coming back to some other things, contexts we've seen for playgrounds, schools. So Tim, you talked a lot about public play spaces. We don't get a lot of call to address issues in public play spaces. We do get a great deal of business out of early learning centres and secondary schools and primary schools. And so the public play spaces are really just those ones where, like I've mentioned, there's a council who oversees the land and they have Section 26 obligations at least. But if they then have employees who go in to do maintenance, including mowing the lawns, watering the lawns, anything even not related to the play space, that council has obligations under Section 23 of the Act as well. And a little example, we had one of these recently in Warrnambool, a huge, very exciting looking slide. I think it's 6 or 7 metres high, very steep. And we got called in because there'd been 2 incidents of kids snapping their arms on the thing, and 1 incident of a parent who got a similar sort of level injury where they and their kid got stuck in the thing. And so we had to look at the whole history of that thing and make a determination and a recommendation about whether the council needed to do anything differently in relation to that. Next one, please, Andrea. Thank you, yes. So here is a breakdown of under the Act. So reasonable practicability, it sounds like a subjective and nebulous thing. To some extent it is, but in fact it's specified in the Act. What does it mean? It means those 5 things, and the first 2 of them are the typical components of a probabilistic risk assessment. What's the likelihood and what's the severity of an outcome if something goes wrong? The next 2 things are about how possible is it to control a risk. So there's the availability of risk controls and what you should reasonably know, what the duty holder should reasonably know about the available risk controls. And the last one is cost. So when I first started working in this space, and I, as Andrea mentioned, come from a long background working in the outdoors sector. In fact, I probably coined that term, didn't I, David? Outdoors sector in Victoria or Australia. The deliberate engagement with risk, I'm a big fan of. Developmental risk, I'm a big fan of it. Lived it my whole life. I've facilitated it for countless numbers of young people, leading them down whitewater rivers for a long time in Gippsland and didn't lose any of them. Not that I can account for anyway. However, this is what the law says, and the law is a reflection of community expectation. So that's the subjective part of reasonable practicability, and where it comes over into what a reasonable person would do is when the poo hits the fan. So when there's been an incident, a person is charged and fronts up to a magistrate or a judge, the standard that a member of the judiciary applies is what a reasonable person would have done. So they take into account the obligations under the law, the actions of the duty holder, and generally they will compare, in looking at these sections, subsections C and D, what they know and what they ought reasonably to have known with all of common practice. So for us, that's where all of your standards come in. Your Australian standards, your ISO standards, all the rest of them. What we don't have in here is any balancing up of risk versus benefit. And again, so even beyond some of the use cases you talked about, Tim, all of the international standards and local standards around risk management, the current one being ISO 31000, indeed has at its centre the first preliminary thing you do before you assess risk, likelihood and occurrence is you determine risk tolerance. And included in risk tolerance is your estimation of benefit. So none of that is formalised in this Act. It just has this blanket thing which can be interpreted as minimise risk, or eliminate risk. No reasonable person believes that's possible. Everyone recognises that risk is not possible to eliminate if you're going to do the thing. Yeah?
I have a question about the Act. It might help me understand this, but is harm defined in the Act? What harm is? And also, is a hazard and a risk the same thing in the Act?
I'll check for the first one and no for the second one, because I have my Act here, the first part of which is a set of definitions. I'm pretty sure not. But this is a source of common confusion. What are the differences? Richard and I were talking about this earlier. What are the differences between hazard, risk and harm? So the answer is, before I get to this, there are hazards. So the edge of this dais constitutes a hazard. Right now I don't have much exposure to the hazard. I now have more exposure to the hazard. So my risk now, so risk is a combination of hazard and exposure. My risk here is higher than it is here. The hazard hasn't changed. No harm ensued because I didn't fall. And I could come and stand here quite a lot of times before I fell and twisted my ankle, which would happen eventually, but most of the time the harm won't emerge from the risk. However, the law tells you to eliminate the risk or to minimise it as far as reasonably practicable. But my quick look in the definitions section under H tells me that harm is not defined in the Act. And frustratingly, there are many important provisions of the Act, such as section 21(2)A of the Act, which is in here somewhere, that says that the employer is obliged to provide systems of work that are safe and without risks of harm, risk of health and safety harms, let's call it, but it doesn't define what a system of work is. So that's frustrating. However, what in practice is done by regulators, including us, and with the judiciary, is that application of what a reasonable person would do. And so from the regulator's perspective, we want duty holders to understand that this exists. So I know from my time in the outdoor sector and now from my time at the regulator, where we do encounter people working in the range of deliberate engagement with risk through activities, including outdoor activities, we think that there's a low level of awareness among providers of those sorts of services of their legal obligations. Often there's a confusion between legal obligations and, say, insurance obligations. We're not particularly concerned and don't really pay any attention to insurance. That's not our business. Civil law, so if someone's going to get sued for harms, that's also not our business, although findings in court for breaches of this law can sometimes support civil action. The two are not connected in any formal way. So Andrea, next slide if I could. What we do look for, despite it not being required under the Act, is this. So what we think is reasonably practicable for everyone, and we do have guidance material on our website around this from which this is extracted, is risk assessment. So this should be an uncontroversial representation of the risk assessment process, similar to the one in the International Risk Management Standard and elsewhere, and that others have referred to in their presentations. So both if we are doing what we call a strategic inspection of a workplace, of which we do many, we will just drop in on people to have a look and see how you're travelling with this. There doesn't need to be an incident. We'll go and have a look, and if you're doing this, we're likely to say, excellent, that looks like at least as far as reasonably practicable. Next one please, Andrea. So there are a number of types of risk. The only ones that we're concerned with really are the top 2.5 of those, and why I say half is that the social dimension of risks are bound up by us with the psychological. So some people will be aware that we have developed and drafted psychological health and safety regulations, which, like all of our other OHS regulations, will sit under the authority of the OHS Act if they're enacted. We keep being told by government that they will eventually be enacted. There will be associated compliance codes to go with those. And so psychosocial risk, picking up on another theme, might have been from your presentation, Richard, apologies if it wasn't, about physical safety improving over time in the community, but mental health declining. we look at both health and safety. So you're right, our stats do bear out that typical physical injuries are declining over time, and claims against the work cover scheme for physical harms, physical direct injuries, what we call blood on the ground injuries, are declining. However, the overall claims against the scheme are increasing, mostly driven by an increase in mental health claims. And tying that actually into this notion of balancing risk versus benefit, it comes down to evidence. So, and again, if push comes to shove and you're called to account in front of the judiciary because we or somebody has believed, and it's going to be us, that has accused you of breaching this act, and you need to demonstrate that you haven't done so, and you're going to go in there and say, well, I'm sorry that Johnny broke his arm, but it was for the sake of his future mental health. We've got the evidence on the one hand of Johnny's broken arm. We've got your word about the likely or possible improvement in Johnny's mental health. So the research pieces we're hearing about today are super important. And that also ties in with risk appetite and risk aversion. So Tim, I think it was your nice stats about sporting harms. I think they differ slightly in Australia, where David will correct me if this is wrong, but I think fishing is in fact our most dangerous recreational activity in terms of fatalities. More people die rock fishing in Australia than any other recreational thing. But having said that, the risks of physical and psychological and social harm, when they're manifest and the evidence is there and there are stats showing them, and the benefit is familiar, so driving a car, yes, we know there's a road toll. We also know, and we're all familiar with, that we rely on that risky activity every day. When you're proposing a new or novel activity that there's both not established data on and not strong community awareness about, you're up against it in terms of reasonable practicability, because what needs to shift is public and social awareness, if that makes sense. So, how to engage educationally with risk-taking. I just want to share, people might be familiar with this. This is a lovely model from Simon Beams and Mike Brown from their Adventurous Learning book from 2016, where they talk about those 4 dimensions of what's required. And the premise, certainly the premise in outdoor education, when I was in the space, we started off with Mortlock's real and perceived risk model that many people will know about. The idea being that when a person's perception of risk is heightened, they're receptive to new ideas. It's a fundamental premise in adventure-based learning and outdoor ed. Partly in order to address some of the real concerns about risk and safety, Mike and Simon created this different model that doesn't necessarily require highly physically risky, actually risky things. And they delved into the psychology and education literature to show that those 4 things are what are really important. Uncertainty is key, and that's actually what we're looking for with that engagement with risk. But even when I look at some of the pictures of playgrounds, when I look at your kids in the parkour, I don't see much real risk at all. And there is perceived risk. You can see through the cargo netting down to the ground 5 metres below, but there's no way you're going to go through it. So that's a construct that you may wish to consider as a subset of saying, look around, look at good practice. And the other thing to say is that despite the constraints of the Act saying that you need to eliminate or minimise as far as reasonably practicable any exposure to risk, there are many familiar and socially accepted activities, including those sporting things that Tim shared, including sending kids to school, including most of the things we do in our daily lives, including with our kids and except for our kids. A lot of it is to do with the perception based on novelty around risk. Next one, please, Andrea. So essentially, yeah, go back to that one. Again, coming back to what is good practice, you have the wonderful body of work in, if you're running outdoor activity programs, of the Australian Adventure Activity Standards. So they've been developed over a long period of time, and they are the thing that we look to when we're starting to look at, when we get an incident in horse riding or high ropes like we had the other day, we immediately go and see, is there a standard? Yes, there is. What did it require? Was that being followed at the time? And that's a first port of call. If there is no such standard, I don't know what the case is with your stuff, Richard, maybe there's not, maybe there is. If there's not, we will look around at what other people do who are providing that activity or something similar. So if there are standards, ISO standards and the like, they can be references. We're slightly wary of those because they're not objective. I'm on a Standards Australia committee and partly on another one. Other people in the room are as well, and they attempt to, the standards auspicing bodies attempt to bring in what they think of as stakeholders, but quite often those committees are skewed by vested interests in various ways. So regulators like us, we view those things with caution. But for some things, for example, amusement rides, which we've had a lot to do with in recent times with the show and amusement ride season, we rely on the engineering standards for those because that's best practice. Okay, that bottom point I can't emphasise enough. I am a systems ergonomist, so I'm a big fan of holistic thinking and try to apply that, as Rochelle mentioned, across WorkSafe to reinforce the point that there is no single chain of events in anything. There is no root cause for anything. In systems of work, there are always multiple factors that lead to all of the outcomes, both beneficial and detrimental. So when something goes wrong, it's because a whole bunch of things have come together in an adverse way. So risk controls, similarly, shouldn't be a single thing, and there should never be reliance on a single thing. It should be holistic. Next one, please, Andrea. So in summary, all of that, I personally think, and I think my organisation would agree with me, that helping young people learn how to engage with and safely manage risk is an important social function. And just on that, I will reinforce the notion that Richard put to us, that engaging with risk is not just beneficial for the spin-off benefits, it's beneficial in itself. We all need to, like I just dangerously demonstrated before by walking to the front of the stage, we need to learn how to manage risk for ourselves and others to function as citizens in this society. And indeed, for our duty holders to comply with this thing that we ask them to comply with, we need all of those people to understand what risk is and how to safely manage it. So for providers and people who are subject to the provisions of this Act, I'd leave you with this idea: take it seriously, be familiar with it, and without sort of spooking you at the last minute, the pointiest end of this was enacted a couple of years ago, which is the workplace manslaughter provision of this Act, the penalties for breaching which are at the moment $19 million and 25 years jail. So the provisions of this Act are heavy. On the flip side, what this is about is harm prevention. And what our organisation is about is harm prevention. I think that might be it. There's a little link down there for our... by the way, that could be quite useful for people who do run small to medium businesses. We run a whole range of education and support services, including financial grants and including grants for research, grants for OHS innovations. We run award schemes every year. We have a whole host of resources on our website, including this thing, OHS Essentials, and that's for small to medium businesses, which I think are organisations with 150 or less staff, where we provide you with free OHS consultancy if you need some education in that space. And next slide, Andrea, and that's it. Thank you. I'll hold the questions till the panel time. Thank you for listening.